Behind me is the White Bear pub, where in May 2006 Lambeth alleged that Brian Pead and his girlfriend engaged in sexual acts. I've spoken to someone involved in the theatre and somebody involved in the pub at that time, and nobody remembers anything about it. Nobody knows anything about it whatsoever. They do remember an incident in 2008 with an autistic young man, but that's it. So it goes to show it never happened. Having sacked a teacher in his pupil referral unit for being racist towards students, male students, and also for apparently grooming female students for one-to-one contact with her outside of school. Following this teacher, having been sacked by Brian, then made allegations against Brian Pead, and this particular one relating to the theatre, the White Bear Theatre in Kennington, and the performance of The Horse Dealer's Daughter in May 2006. This complaint was made some 7 months after the performance had taken place, and Brian's female companion from that day, Ipak Yilmaz, even wrote an email rebutting all of the allegations of what happened during that performance, stating the allegation is completely untrue. Alleged that I gave Brian a hand job in quotes during the performance. I am astounded at such an allegation for the following reasons. She quite rightly points that had the allegation been true, it would have been possible for everyone in the theatre and all the actors and actresses to have witnessed the act, since it was such a small theatre. And she says when she met with Annabelle, who was another teacher, who was an actual teacher in Brian's pupil referral unit, after the performance, at no point did she bring the matter of this alleged incident to either Brian or my attention. At no point did she look embarrassed or shocked, as the allegations claim, and in fact I recall her and Brian hugging one another as we left. Hardly the action of someone who was embarrassed or shocked. If, and she very significantly points out, if such an incident had indeed taken place, I would have thought that the police would have been called and the theatre management would have been informed. A very good point. This allegation, interestingly, when Brian went to an employment tribunal about 2 years later, a very similar allegation was made against Brian. One wonders, maybe, and it has been suggested, to discredit Brian should he have won his employment tribunal. It's certainly the allegation of events that happened in Days Lane, where he lived, seems to have some echo of this allegation, which is very mysterious. And things get more and more mysterious the more you look into Brian's cases. Very, very mysterious. And of course we know now that what happened to Bulick Forsyth in Lambeth Council when he was going to report child abuse in the council, he ended up dead himself, and that's never been investigated properly.
As the book called Framed, this book is actually going to press tomorrow, and this book is the true and compelling story of local authority and police corruption, which led to an innocent man, me, being charged with false allegations of sexual offences against younger women and wrongly convicted of a crime against a 14-year-old girl who never even existed. So, incitement of a 14-year-old girl to engage in sexual activity. She never existed. And if you look at the Sexual Offences Act 2003, Section 10, incitement, it says, the law says, person A must incite person B. It's that simple. So of course if there is no person, you cannot be guilty. But
this book unpicks a Crown Court trial at Southwark in 2009 and exposes abuses of process in every element of that trial, from a jury that isn't sworn in properly, selected by ballot or names called out, to key witnesses to illegal police activity not being called by the defence, to unsigned witness statements being entered as real evidence, and the catastrophic failure to call the IT manager of a social networking website, the Face Party website, whom the court is told has emigrated to Australia, but who is, according to his OCV, still living in London. Discover how in a 10-minute house search of Brian Pead's friends by the police with an illegal search warrant, the police seize Brian Pead's friend's computer without placing it in an evidence bag before returning it 4 months later to its innocent owner with the hard drive burnt out, and the evidence of Brian Pead's last conversation with the supposed 14-year-old girl posed by a police officer where he told her to fuck off, completely wiped and erased off and removed from the evidence in the trial. Celebrity gangster Dave Courtney features as he shares a cell in the Belmarsh prison with the innocent man Brian Pead, renowned author of books on the entire history of Liverpool Football Club from 1892. Read how the defence barrister fails to properly represent his client despite being aware of his innocence, and how a Crown Court judge unlawfully imposes a deadline on a jury, forcing them to reach an untimely and perverse verdict against all the principles of natural justice. 4 years later, the barrister attempts to blackmail his former client in an attempt to prevent the publication of this book. When appearing in court as a Mackenzie friend for a farmer against energy giant E.ON, who are claiming an £11,000 debt against a non-existent meter, Brian Pead is arrested by armed Norfolk police for an alleged criminal damage to a car said to belong to E.ON meter readers, but who are clearly bogus, because they did not have any meter readers on them visible when they came to the farm and came without any apparent uniform or ID. This is one of the police officers who attended the scene. At this time, January 2008, Brian was undertaking an advanced diploma in humanistic integrity counselling. Much of the contents of this course was of a psychosexual matter. He was counselling clients with significant sexual issues who had been sexually abused in the ages of 5 and 11, which started in a children's home in Harpenden, Hertfordshire. He therefore knew more about the subject of child abuse than the average person in the street. He had been deeply traumatised when it first occurred and had thereafter developed a lifelong interest in the subject from a psychological and counselling perspective. He instinctively knew, therefore, that this person claiming to be a 14-year-old girl in the chat room was not, in fact, a child at all. He knew that it was an adult, and it was his belief that it was a middle-aged male, or certainly someone with a deep interest in the subject of paedophilia. He was, of course, right. Brian Pead's Southwark trial was told that the Face Party website had gone into liquidation. In actual fact, the company, CIS Internet Limited, had actually gone into liquidation, but the Face Party website was purchased very rapidly, or ownership rapidly transferred to Anarchy Towers Limited of Langley House, Park Road, East Finchley. At no point did Brian's barrister inform the judge and jury that the undercover policeman had produced 2 completely different statements. The first statement, produced in June 2008, stated that he had in fact been in the chat room on the Face Party website, but more than a year later the police officer changed his statement, Shades of Hillsborough, and denied ever having been in the Face Party chat room. This was the first of many anomalies which Brian's barrister failed to bring to the attention of the court in one of the most abusive trials ever seen in a British courtroom. On the 14th January 2008, Brian travelled to the South London Employment Tribunal in West Croydon. He represented himself. Lambeth arrived with a barrister and a flanks of Barratt Council executives, 14 in all. This in itself taught him a lot. He knew that Lambeth Council would not be sending so many executives without reason. By sending such a large number, Lambeth was showing that they were rattled by Brian's claims against them. On the evening of the 14th of January 2008, Brian returned home and went online. He was sent a request on MSN and randomly added the person and occurrence which happened on a relatively regular basis. Little did he know at the time how important that random act was to prove in his life. On the 28th of January 2008, the person who had been added as a contact on the 14th of January contacted Brian at 16:30 and 30 seconds. It is important to note here who was doing the chasing. It was a person purporting to be a 14-year-old girl. She had just been in a chat room and randomly asked for money for sex, stating that she was 14. drama student changed her statement to say that she saw Brian at the window on the right with the blue banner in it. They claimed, her and the other drama students, that they had unobstructed views, and yet there is scaffolding all across the front of the house and a ladder. One might wonder why the woman failed to keep her curtains closed ever since she received the note back in October 2007, in which Brian had informed her that she could be seen. One also has to wonder why the police took this allegation seriously. It does not take an Einstein to work out that you could not possibly see a person's face from 100 feet away in the dark at a window which was partly obscured by 3 scaffold poles and a ladder. Furthermore, the windowsill in the front bedrooms in Brian's house were above his groin area, so it would have been impossible for anyone, let alone someone from 100 feet away in the dark, to have seen him with his hands down his trousers, as the woman claimed. Although both cases against Brian were of a sexual nature, they were not capable of being joined because their execution was significantly different. Exposing oneself to a group of 3 adult students is an entirely different act from going online and inciting an alleged child to engage in sexual acts. Indeed, the ages of the alleged victims were different. The students were in the 20 to 22 age range, and the alleged girl was 14, played by an undercover police officer. Thus, these separate indictments should never have been heard in the same court by the same jury, but the issue of misjoinder was a much larger issue because, as we have seen in an earlier chapter, in February 2009, the Crown Prosecution Service, with the same, I won't say the name, representing them, applied for joinder at Woolwich Crown Court before Judge Charles Byers. Quite rightly, Byers refused to join the 2 cases, stating that the 2 allegations did not contain a common nexus. The Crown Prosecution Service, however, would not relent. They ensured that the exposure case collapsed at Woolwich Crown Court and that it was transferred to Southwark Crown Court, a court with a higher record of convictions when compared with other Crown Courts in London. In a case of misjoinder, any conviction is automatically overturned. In R. Regina v. Newland, 1988, it was held that the misjoinder of offences is in contravention of Rule 9 of the Indictment Rules 1971 cannot be cured by a direction for separate trials of the misjoined counts. If a court proceeds to try a misjoined indictment, the proceedings will be a nullity and any resulting convictions will be quashed. But the story against Brian by the police becomes even more full of holes when Geoffrey and Roy Bacon wrote using the Freedom of Information Act and the Data Protection Act of the City of Westminster Magistrates Court to obtain a copy of the police submission to the magistrate in order to obtain the warrant exercised at their address. The Magistrates Court has continually refused to provide a copy of the submission by the police. The police have continually refused to provide a copy. It is not until the 29th September 2008 that the search of the Bacon's house is mentioned in the Chris report. The warrant at Mr. Bacon's address was executed on the 31st of July 2008 and computer seized. This has been examined and no further evidence obtained. The computer has been returned to owner. The emphasis is the author's. At this stage the computer had not been returned to Geoffrey Bacon, so this is a false entry. If the computer belongs to Geoffrey Bacon had been examined as this entry claims, why is Geoffrey Bacon still waiting for a copy of the forensic report which he is entitled to? He had written at least 12 letters to the police, to the forensic company that the police used on Brian's computer, and had no response with a report. Roy Bacon was not asked to sign a receipt for the return of the computer. It was not in an evidence bag. There was no chain of custody. Later that evening, Geoffrey Bacon returned home from a day's building work. He was relieved to find that his computer had been returned because he needed it to operate his business. He took it to his bedroom, he connected all the wires, he plugged it in. It did not work. The hard drive had been burnt out. This is something that greatly affected Geoffrey's business as a builder, and the authors are therefore minded to believe the accounts of 2 men of great integrity and with Home Office clearances to work as builders in police stations and royal buildings. Okay, so these are 2 copies of a search warrant issued at the friend's address of Brian Pead's friends, where the computer he used, he had a conversation with a supposed 14-year-old girl acted by an undercover police officer over the internet. Now you notice here that executed is handwritten across each copy. There are 3 carbonated sheets. One goes to the court, one stays with the police, and one stays with the occupier. Nature of carbon paper is whatever's written over the top should come through exactly the same. It should be the same size, and the handwriting should be the same. Now that isn't the case here, because you'll see that the D of executed on the occupier copy is 6mm wide, and it's over the word Gravelwood. On this copy, it's well above the word Gravelwood, close, and it's 9mm wide, so it's significantly bigger. Another interesting feature is there are two line spaces between the second and third paragraph on this particular copy, and yet strangely enough there's only one line space between the second and third paragraph on the occupier copy. Notice also that if we put the E's of executed together, one is like a half moon and one is much squarer. So something is a bit strange here. Here is a paper customer book with carbon copy paper. This is carbon paper in blue. If I write on the paper over the carbon paper, it's just under a centimetre, 9mm. And 9mm again. Notice also that the E of executed on both copies is different. This one is more square and this one is more rounded. Now, for more explanation, the warrants used by the Metropolitan Police consist of 3 carbonated warrants joined together. The top copy is left with the premises searched, the second copy is sent to the court for their records, and the third copy remains with the police. The top copy is white and the second copy blue and the third copy red. This was a copy of the search warrant issued to Roy and Geoffrey Bacon in 2008, friends of Brian Pead's, where he had borrowed their computer in their house to make use of it on a number of occasions within their house. This was a copy of the warrant, same warrant obtained by freedom of information request rather than given over by the police as this one had been. I'm interested here in the difference between the signature of Nicholas Evans on the two copies and the fact that I've enlarged here that a third sample I've obtained of a Russian case that came before Westminster Magistrates Court before Nicholas Evans retired. You'll notice that his signature is different to those in the one in Brian Pead's case. The N slopes to the left and is separate from the I, whereas it's joined to the I and slopes to the right on the ones in Brian's case, the copies in Brian's case. The C and the H are different. They're scrawled on the ones in Brian Pead's case. The A and the S are different. The E is different on Evans, and the flick underneath Nicholas Evans' signature is missing on both the copies in Brian Pead's case. It's my opinion that something is amiss here. Maybe this is not the same person signing the signature, and perhaps this is a rather poor imitation of the signature of Nicholas Evans, which is an authentic copy here, which he gave comments on in relation to the Russian case, ironically about corruption. I've got 2 emails from Woolwich Crown Court saying that in 2012, a case brought against Brian, the prosecution offered no evidence and the jury were discharged. This is very mysterious, since the CPS in a recent television documentary claimed to consider all the evidence very carefully before they decide to put a case in a court diary. What happened at the case management meetings, one has to ask. This was a case where false evidence was entered into court. So, just as with Brian Pead, the police get their headlines in the local press, in this case the News Shopper, but the real story of what the police got up to is not gone into and doesn't come out. In actual fact, in this case, these 2 brothers were driving to Greenwich near the Woolwich flyover. In the car with him was his brother Asante, and two female friends. At around 6 p.m. the car was brought to a hard stop by armed officers in an unmarked car. The officers shot out the tyres, smashed out the car side windows, and proceeded to thrust their weapons into the faces of the Williams brothers. They then dragged him and the three passengers out of the car. Officers used tasers and pain compliance techniques on the men who did not resist at any point during the arrest. Officers accused the brothers of being terrorists and accused of having repeatedly racially abused them at the time the arrest was reported in the local newspapers. Due to the severity of the injuries of his head, Asante was taken to hospital in the assistance of paramedics, and no charges were made against him. The police explained that the car was targeted because it was linked with an address associated with Lee Rigby's murder. The address in question was that of Mr. Williams' cousin, a black Muslim who has not been approached by police to date. Hassani was charged with possession of a Class A drug, but crucially, despite the nature of the stop, was not charged with any offence related to terrorism. A court hearing which took place in October put the trial back on a warned list to the 6th of April for unspecified reasons. In November, Hassani pleaded not guilty at a hearing at Woolwich Crown Court. On the 8th of January, the prosecution formally offered no evidence in respect to this charge, just as with one of Brian Pead's cases. A complaint about the way the Williams brothers were treated is currently being investigated, and they are also preparing to pursue a civil case against the Metropolitan Police. And that's the two Williams brothers. Police used terror laws to snoop on a mirror phone records after it was revealed a chief constable lied about his fling with a colleague. Cleveland bosses accessed data after reports that Sean Price blew public cash on the relationship and other allegations of racism within the force. One MP said, "This is shocking. We do not live in a police state." Turn to the matter of Brian's MP in Norfolk. Sir Henry Bellingham, who was previously just Henry Bellingham, who apparently after 4 years of being aware of Brian's case, or cases, has still been unable to deliver any results, it seems. I did ask Henry Bellingham, who tries to appear helpful, so it seems, in correspondence, whether he would do what was done in the case of Ian Burgess and write to the Solicitor General and ask, as Ian Burgess's MP Vince Cable had done, whether it was an appropriate use of public funds for the Crown Prosecution Service to go chasing a man through the courts over an argument that had started about £15, whether it was an appropriate use of taxpayers' money. A perfectly legitimate question to put to the Solicitor General. I never had any reply from Henry Bellingham on that point. I raised a number of concerns with Henry Bellingham about things like money getting to Brian, mail getting delayed to Brian Pead when he was in prison, and he again made no comment on these. His involvement in the case also involved sending a birthday card, and in another farcical case against Brian Pead, he was accused of impersonating a barrister at Kings Lynn County Court, where he went in with a farmer who he was friends with at the time. One of the court staff who came into Cambridge Crown Court to testify claims that when she asked Mr. Pead if he was counsel, he had answered yes, and this was taken to mean that Brian Pead was somehow guilty of impersonating a barrister. This is absolutely ridiculous, since a county court, as it says here in the litigants in person document, and incidentally Brian Pead never spoke on behalf of the farmer who came into court with. The Courts and Legal Services Act 1990 say lay representatives can have rights of audience. Also, companies' staff can have rights of audience, official receivers can have rights of audience. So how is it possible that a court that has all these dispensations above all other courts to have non-legally qualified staff, people who are not barristers, as counsel to represent people, how could a court clerk in such a court of this particular sort therefore assume that he was representing himself as a barrister? Incidentally, Brian Pead, as one of his careers, was a counsellor, but that's by the by. On the 31st July 2007, Brian Pead received a letter from the chairman of the disciplinary panel at Lambeth, which it stated he was guilty of 10 of the 14 charges against him. In a similar case at Lambeth, a head teacher, according to the Times Education Supplement, who was suspended from school when his deputy made false allegations about being bullied, has described the past 3 years as a nightmare, days after winning a case for unfair dismissal against Lambeth Council in 2011. James Walker, who had been head of Henry Fawcett Primary School in Kennington in London since 1999, was left feeling suicidal after being accused of bullying and harassment by an assistant head teacher in September 2008. The Employment Tribunal said the investigation process amounted to a fishing exercise which focused on obtaining the most damaging information about Mr Walker. The Tribunal was struck by the level of Lambeth's hostility towards Mr Walker. In evidence presented to the court, the Tribunal heard that the two teachers had told the Council's whistleblowing department shortly after the suspension that the deputy was fabricating her claims against Mr Walker, but this evidence was not acted upon by Phyllis Dunipace, the Executive Director for Children's Services at the time, pictured here receiving an award from Prince Charles. The extent of cover-up by the elite goes far-reaching within the British establishment and society. Diana was at best killed by, in manslaughter by the negligence of the way her crash scene was handled, and her life could have been saved had the ambulance not been so ridiculously slow to get at hospital and the doctor in charge so ridiculously slow to get her out of the undamaged back of the car that she was in, along with Dodie, her boyfriend, both of whom could have been saved if they had been got to hospital within a reasonable time. Certainly Diana was still conscious when she was found. All of this has been covered up by the press, although it did get out in the inquest, the farcical inquest where the BBC's own royal reporter was fast asleep snoring during large sections thereof. This is the case of Bulett Forsyth at Lambeth. The man's murder may be linked to sex abuse cover-up. Again, this is being covered up, and the Lambeth child abuse survivors have pulled out of the national inquiry, citing what a farce it has become, and a circus in which they do not wish to be further involved. Lambeth worker told colleagues he would spill the beans. A previously unseen report revealed Mr Bulett Forsyth was beaten and burned to death in his flat not long after. To this day, over 20 years later, nobody's been brought to justice for this. It is quite clear that the people in charge of our country do not really care about us. Whichever ones you vote for, they're all the same party, just different wings. Whatever party colour or rosette they wear, they don't care about us. They pretend, and people on the whole are unaware and don't realise that they're being lied to. All Gravy campaigners claimed Amber Rudd stitched them up, having promised that there would be a full investigation and inquiry. She reneged on her promises. To add insult to injury, the ministers in our government even went to court to try and stop themselves having to be brought to account for the poor air quality in London that's killing tens of thousands of people who voted for them. And to add further insult to injury, they could not even stop, or make any effort to stop, the South London incinerator in Sutton, which will only add to the worsening levels of pollution in central London that are killing thousands of people. This was even instigated by the Liberal Democrats, who are just as hypocritical as all the other politicians and political parties, claim to be bastions of the environment.